On with the show. Part one, EIA's common complexities. And as mentioned, we're going to cover the Rochdale envelope and cumulative effects. So our learning objections in this unit or subunit are to provide you guys as planning officers with a core understanding of what is the basis and the application of the Rochdale envelope within EIA, or what's also sometimes known as design parameters around the application. How does that fit into the EIA process, and how does that then link in to your planning applications for EIA developments? Neil's going to cover that. Then I'll come in and give you some coverage of key expectations around cumulative effects between our EIA development that is seeking consent and other developments that exist and are out there. And then at the back end of that, Neil is going to come in and give you a quick summary of a recent piece of case law that you can see referenced there, to just give you an update on that, as it has a touch upon or link in to aspects of cumulative effects. Anyway, I'm now very pleased to hand over to Neil. So over to you, Neil, and I'll take myself off camera.
Thanks very much, Josh, and good morning, everyone. As Josh mentioned, I'm going to talk about the Rochdale envelope. Was conscious really when we were talking about, what are we going to cover? Rochdale envelope, it's one of these things that it gets mentioned a lot, but doesn't get explained what it really is. So it can be one of those frustrating ones that if you're in a meeting, someone talks about a Rochdale envelope, and you may well be sitting thinking, but what is that? But don't get a chance to actually ask. So this was a good opportunity just to demystify it all. And actually, although this section is being described as common complexities, it's not actually particularly complicated when you come down to it. And actually, that's the beauty of it. It's a very practical device for actually letting us all just get on with things. As you can see on the slide, I've set out, well, what's the problem and why is the Rochdale envelope the solution? The problem is in Britain, Scotland and England, we have the potential to do multi-stage consenting. In Scotland, we have the ability to apply for planning permission in principle, PPP or PPIP, and as part of that, there's a condition requiring you to submit further information for approval. That subsequent application known as application for approval of matters specified in condition. So that's either AMC or AMSIC, or there's a few different abbreviations. The problem with that and the interaction with environmental impact assessment is the nature of a application for planning permission in principle is you're not providing full design details. So the problem, as mentioned on the slide, how do you address environmental impact at that point when you don't have full details? Or indeed, some people might say, it's not how, but can you? And it almost poses that question of, for EIA development, is applying for planning permission in principle even really competent? And the answer is yes. The solution is within the application, you identify parameters of development, you address the environmental impact using those parameters, and then you grant the permission subject to conditions requiring the development to fit within those parameters. And the parameters are the design envelope, the Rochdale envelope, and it is really, certainly in principle, that straightforward. Obviously, for individual projects, there can be complexities around exactly how it works through. So that's the basic introduction. And then moving to the next slide, just to explain why Rochdale, inevitably it's because the case was involving a site in Rochdale. And just mentioning this as the example, it's basically the courts approving this envelope style approach and saying, yes, this works, it fits within the law. As I've set out, it was the business park development, outline planning permission, as it is in England. It's the same thing pretty much as planning permission in principle. And the court upheld the outline planning permission because the application included specific parameters. The EIA took account of potential significant effects flowing from that flexible approach, and the planning permission, the outline planning permission, had stringent conditions to ensure the project remained within those anticipated boundaries. So it works, providing the consent conditions actually make sure the project will stay within the design parameters within the envelope. So there's a bit more thought has to go into it as a result. And then on my final slide, I just set out some examples of this approach in action. So the Rochdale case demonstrates that for built development, the use of parameter plans. So for instance, I'm involved in an application for a data center. Because it is a speculative development, there's no end user yet. The developer doesn't want to be pinned down to a detailed design, and the application sets out a series of parameter plans in the expectation that the permission will then be conditioned around those parameter plans. That fits with the approach that quite often happens, where it's a speculative style development, or it's a development where the applicant doesn't know the final design because the way the project will be procured, it's a type of design and build contract. So the contractor will have final responsibility for the final design. And again, to address that commercial reality, as it were, the practical reality, the permission has to have some flexibility built into it. So that in that scenario, the contractor would apply for approval of the final details. The second example I've provided, there's obviously a lot of activity on and offshore around wind energy developments. EIA typically there uses what is referred to as a candidate turbine. And the application, the EIAR sets out, this is not necessarily the turbine that we are going to use, but it is sufficiently representative that it can be the basis for doing the environmental impact assessment. So again, it's really just setting out a parameter. The eventual turbine will fit the same parameters as this candidate turbine. So the EIA is effective, even though it's not pinning it down to a final design of turbine. And again, the reason for that is primarily commercial, that until the consent has been granted, the wind farm company don't want to pick a turbine. And because of how long it takes to consent a wind project, and the turbine market is actually quite fast moving, it's fairly common that by the time the consent is granted, the candidate turbine isn't actually on the market anymore. The market has moved on, but because you've used that as an envelope, a parameter, you're not stuck with having said, that's my turbine. You can go into the market, and as long as the turbine fits the envelope, then you don't need to go back and completely revisit the consenting. And then the final example I've set out there, it's an extreme one, but I thought it was just such a brilliant illustration of this concept. A ferry terminal in England, and to future-proof it all, what they did was, within the environmental impact assessment, they used what they referred to as a design vessel. That's vessel as in boat. So it's a boat that doesn't exist, it has not been built yet. They're projecting into the future, saying this is where boat design might go. The point being, the ferry terminal needs to be big enough for future vessel sizes because it's got a 50-year design life. So I thought that was quite an interesting example of the Rochdale envelope being a boat that doesn't even exist yet, and indeed might never exist, but presumably the designers have built in sort of maximum parameters so that even if it doesn't exist, whatever boat is on the market in, say, 40 years' time will not exceed that envelope. So just some useful examples there of the operation of the Rochdale envelope in practice. So that was a fairly quick gallop through Rochdale envelope. And I'm now just going to hand back to Josh, who's going to look at cumulative effects.
Thank you very much. Yep, all is good. Okay, thank you very much, Neil, for that. Really, really useful whistle-stop tour, as unfortunately we have to do today in terms of getting through our different coverage. But yeah, really useful explanation there of the Rochdale envelope and yeah, how it fits and why it has come forward and its usage within our consenting processes. You can ask questions. Remember, use the Q&A, fire those in, and we'll answer those. But I will now crack on and talk about cumulative effects. So these are a complicated area, unfortunately. Why cumulative effects? You know, why are we having to think about this complexity of other projects with our project? We're only consenting the one project. Well, ultimately, it all comes down to what we've talked about throughout the course, which is the fact that EIA ultimately is interested in significant effects, however or wherever they may occur. So the regulations talk about significant effects on the factors, and those factors are population, human health, biodiversity, etc. You can see those on the screen. And it's not necessarily just the direct effects that come out of our developments, but it can be interactions between those factors. It can be secondary, cumulative, transboundary, and all these terms appearing in the schedule of the Schedule 4 of the regulations, setting out what needs to be, or if it's relevant, what needs to be covered in the developers' EIA reports documents. So cumulative effects is there in the legislation, but also cumulative effects is then used in practice. And this is certainly one of the areas where complexity can emerge and where some confusion can emerge. So I thought I'd just address that up front before we actually dive into what the regulations say cumulative effects are, what the law says about it, and then look at some different types of cumulative effects. So we have some kind of catch-all terminology that has come partly out of academia, partly out of practice, and certainly around the time that PAN 1 2013 was being written, so what we're talking 15 years ago, this terminology of having intra-project cumulative effects and inter-project cumulative effects to describe some of these range of complexities of effects that occur, the interactions within the project on different components of the environment, different parts of the project operating on different things, as intra within the project cumulative effects, and then these inter-project between the project seeking consent and others. That's out there, it's used, it's in our PAN 1 2013, so we need to be aware of it, but it does generate confusion. So we're going to take a step back from that and just look at cumulative effects as they're described within the EIA regulations, and that's what we're going to focus on. There is an ICEP guidance document that's in production at the moment that will seek to look at this, and the hope is that that will be out and launched by October this year, and therefore something that we can present and discuss at Scotland's EIA conference that hopefully some of you as planning officers will be able to come along to. But in terms of the legislation, so taking ourselves aside from what practice might say and how things might be written, in scoping documents that come to you from developers, things that come in letters, in consultations, what the regulations actually say in terms of cumulative effects are effects arising from projects undergoing EIA and other projects. So that's what cumulative effects are in terms of the law and legislation, is we're looking at the effects that result both from our project on the environment and other projects that can cumulatively impact on things. And the slight pause there was trying to get my head around the English language to not say interaction, because that is a separate part between the factors, or say combined effects, because that is the terminology used in appropriate assessment under the habitats regulation. So it can be quite hard to talk about these things and just stay within the narrow confines of the language used in the legislation. So let's quickly take a look at where these sit within the regulations themselves. Where do we actually see reference to cumulative effects? Well, not in the regulations, as in regulation 1, 2, 3, etc. It comes in the schedules, and they're referenced particularly in relation to screening. They're there within the screening criteria, both in terms of the criteria in relation to the description of the development, that's schedule 1.3.1b, and some of those description as we describe the developments as part of the application or the request for a screening opinion. The applicant should be setting out, some indication of if there are other projects that are particularly around it that could have cumulative effects, and then also in Schedule 3.3g, which is the different types, the characteristics of the potential impacts that could occur. And you can see that quote there, the cumulation of the impact with the impact of other existing and or approved developments. So when we're thinking about screening, one thing that could trigger an EIA is the potential for cumulative effects. But obviously, in far more cases when we're screening things, it's going to be significant effects directly from our project rather than significant effects that are coming from our project and others that may already be there or are already approved. Then the other reference is within the developer's EIA report in terms of the contents that might be relevant. So you'll remember from one of the earlier webinars when we were talking about EIA reports that within the regulations themselves, it's a kind of minimum content of the environmental report, and then Schedule 4 sets out other content that is required to be there if it's relevant. And within this, in terms of different type of effects, it talks about accumulation of effects with other existing and or approved projects, and we need to take into account existing environmental problems that relate to the area in terms of the importance of the environment and the use of natural resources. So effectively what we're trying to look at here is, could our project and a number of existing or projects that have been approved but perhaps not fully built and operational yet, could they be causing a significant effect that individually they wouldn't have caused? And in particular, we want to focus on existing environmental challenges. So, you might have some air quality problems where, they're already beyond certain legal requirements or health limits. There could be sensitive sites that are already, not up to scratch, or water bodies under the Water Framework Directive, and linking into these kind of things. But ultimately, we need to start from our project. Now, the regulations you'll see in both cases here talk about other existing or approved development, existing or approved development. So in theory, and this was one of the intended changes in the 2017 regulations and from the 2014 change in the European directive, was to try and streamline the process, try and give a bit more focus to our consideration of other projects. So the regulations saying, well, let's try and limit these to other existing or approved projects. What we'll see, however, is in reality, we tend to push beyond that in practice, and there's some very good reason for that. And in fact, the government guidance in terms of the circular and particularly in relation to practice will often go further than what the regulations say in terms of things that either are existing or approved but not yet kind of fully constructed, to look at some forthcoming developments. And you say, well, is this acceptable? Why are we doing this? Well, there are actually some very sound reasons for doing this. So the timing, of course, of the EIA reports coming in from the developer is somewhat before the actual date that the consent decision is going to be made. And you'll remember in our webinar this time a month ago, when we were talking about that from submission to consent, there's obviously consultation periods, there might be supplementary information requests, we've got to get it into the decision schedule, etc. But that's the EIA reports. The actual assessment that has gone into that report might well have been undertaken or certainly scoped 6 months, a year before that. So inevitably, when the consultants, the competent experts working for the developer are scoping the requirements of the cumulative effects, they have to take a bit of a speculative look forward and say, well, what other projects are coming up around us that we're aware of, and what might end up getting consent before us? And there's a very good reason for that, and that's because within the regulations, your reasoned conclusions on significant effects that need to feed into the decision-making process, they need to be up to date at the point that the consent is made. And obviously that consent is going to be decided whether it is to give consent or to refuse consent. That decision is going to be months, if not potentially years ahead or after the scoping process has been undertaken for the EIA. So inevitably, EIA reports have to be a certain amount speculative to look forward. Their project might get delayed, other projects get consented in front of them, and then you, as the decision-making authority, if that project hasn't been considered, might feel obliged to make a supplementary information request. So even though on the last slide, the regulatory references, screening, it's in the criteria, EIA report, it's there in the requirements, actually, a key element for getting cumulative effects right is the scoping process. If we don't get it right at scoping, if we don't identify the right things, if we don't work out and get the right content into that EIA report, then we are going to risk the need of you guys as planning officers needing to request supplementary information about other projects that get consent before our project is taken forward. So the other projects that we're considering are not just those that are existing or approved, but will inevitably have a little bit of a grey area into some of the other projects that are advancing at the time. So moving on from that, to just think about some of the different types of cumulative effects that can occur. So a common type of cumulative effect is one that's called additive. So we have, say, our developments or the development that we will be looking to consent, and another separate development, one that's perhaps already existing, and they're both having the same type of impact. So, they're going to take away some kind of mixed grassland, or they're going to have particular noise impacts on a community, or they might have some setting impacts on a heritage feature. They're both having impacts onto that same heritage feature or that same receptor. And as a consequence, even though individually the impacts might not be considered significant on their own, when we take the accumulation of them together, the overall impact of those two effects on setting, or changing the kind of construct, what we're seeing in an area, can have an overarching cumulative effect. So an interesting case example of this was Liverpool Docklands. It's a World Heritage Site, but it has been highlighted that it might lose its World Heritage status because of a sports stadium development, some shopping complex developments, some tower block developments, some office developments, all of which have been separate and developed over time, but cumulatively their impact on the setting of that World Heritage Site could potentially mean that it is no longer considered a World Heritage Site. So there's two different variations of this that you might see referenced. One is spatial crowding, and that's what I've just described. Over time, the amount of space left around a feature is slowly filled in with different developments, and ultimately the context of that development could be lost. So that's something that is sometimes described as spatial crowding around a feature. Another thing is known as temporal crowding, or kind of time-based crowding, and this is where there's a lot of activity either all at the same time or very close to each other that then can have a longer term impact. So we might say, well, we're going to do some work in the River Tay, and it's going to be near a sensitive habitat, and it's only going to last our construction disruptive noise into the water environment, and the vibrations and the impact on fish and mammal species, etc., is only going to be 3 months. But there's multiple other developments that are going on in that area at the time, so there won't be any quiet space, or there's a number of other projects that are going to go on before that and after that. So actually the cumulative impact is far bigger. So those are all additive types of cumulative effect. Another type is something that is synergistic. I'm not going to go into a lot of detail about this, but our development has one type of impact. So if we think about a river, our development is perhaps a energy plant, and it is taking water out to help its cooling systems. The consequence of our development is that the water temperature in the river is going to be raised slightly, and maybe the sensitive species down the river can tolerate that. It's not its ideal situation, but it's not considered to be a significant effect. However, we have a quarry development also upstream, and that is going to generate sediment into the river. So we're going to get increased sedimentation or increased sediment load in the river, so there's going to be less light coming through, increased water temperature, and the synergistic consequence of those two things happening to our receptor downstream, say a kind of a freshwater pearl mussel or something like that, can be that you push it too far out of its safe zone, and we get this third impact, this consequence, this synergistic interaction between the two different developments effects that leads to a significant effect. Now, it's not for you guys as planning officers to kind of be identifying these. That's obviously for the competent experts and for statutory bodies to be feeding in their perspective. But obviously, it's for you guys to be looking at these and reviewing these and thinking about them as part of the EIA report. And of course, there's various guidance available. The circular and the PAN I've already mentioned. We have the EIA handbook that is still available, so produced in 2017, still on the archive pages of HES and Nature Scott now, but still very relevant. And then if you're looking at onshore wind particularly, Nature Scott has cumulative guides for onshore wind for birds and landscape and visual, and of course not relevant to our particular jurisdiction, but there is some quite useful guidance on the process that is generally followed by consultants for EIA reports within the England and Wales Planning Inspectorate Nationally Significant Infrastructure Advice on Cumulative Effects Assessment. I will stop there, hand over back to Neil, and we'll look at a piece of case law that touches upon aspects of cumulative effects. Over to you, Neil.
Thanks, Josh. And it's interesting you introduced that as touching on the concept of cumulative effects, because I think sort of echoing what you were saying, in a lot of areas of EIA, language and terminology can be quite difficult, and in many ways makes it more difficult than it has to be. So wanted to talk to you about the Rochdale Farms case because there's a lot of discussion within the profession about it, and because it's about EIA, we thought we couldn't complete the programme without mentioning it. It is still a fairly recent case. The appeal period actually has only just, the period for an appeal to be submitted has only just expired. There isn't an appeal. So it is still fairly new. We're still getting our heads round it. So again, today, what I wanted to do was just give you as much of a straightforward explanation as I could, so that if you hear about it, you at least have an idea of what it's all about. The implications are still emerging, still being talked about. I think it will take us at least the rest of this year, if not longer, to really see those implications become clear and responses within the consenting system to emerge. So it is very much an evolving situation, and conscious we've got a Q&A in a few minutes. I'm sure you've got lots of questions about this case. As I've just said, there's so much uncertainty about the implications. There might be a limit to how useful any of my answers might be. But the introduction to what the case actually says is about the Wilmuir wind farm. So you may hear it referred to as the Rochdale Farms case because that was the party that challenged the decision. It's about the Wilmuir wind farm, so you might hear it described as the Wilmuir case. Wilmuir wind farm, it was sub 50 megawatt, so it was consented through planning. It was granted permission on appeal, and what Rochdale Farms challenged was the reporter's decision to grant planning permission. The narrow issue, the EIA for the wind farm did not include the connection of the wind farm to the grid. That might, with benefit of hindsight, seem like quite a major omission. The whole point of a wind farm, or indeed any other generating asset, is to generate power, and typically the purpose is to generate power and connect it to the grid. You can occasionally have generating assets that don't connect to the grid, possibly a wind turbine or some solar panels feeding power to a high energy user factory next door, and not requiring a grid connection. But in the main, the intention is to transmit power to the grid. It's just been the practice in Scotland that applications for generating assets have not included details of the grid connection. There are very good practical reasons for that, because without getting into a description of how the electricity industry works, grid is completely different from generation. The developer of the wind farm has to liaise with the transmission operator. The transmission operator is responsible for the grid connection, and summarising what is a very complicated setup, the details of the grid connection will only ever be drawn up once the generating asset has got permission. So there's a bit of a chicken and egg here of the generating asset needs to get permission. If the generating asset needs to include information about the grid, that is quite awkward, because the grid connection details will typically only be available once the generating asset has got consent. So there's a practical problem there. So that's kind of the background. What the court decided, they quashed the decision because the reporter had failed to address the critical issue of whether the wind farm and the associated grid connection are a single project. And this is a good example of being careful about how you interpret court decisions. That is the decision. The reporter, in effect, didn't ask the right question. So the court are saying it's not our job to answer that question and decide then whether the project should be granted permission or not. Their job is to say, was the right question asked? No, it wasn't. So they've quashed the decision and it goes back, and a new reporter will be appointed, ask the question, and then decide, having asked the question, what then happens to the rest of the appeal procedure and whether or not consent would be granted again. So it's a fairly limited decision that the court have issued. The interesting thing within all of this is the reporter perhaps fell into the trap, the terminology trap really that I was talking about, of referring to this as salami slicing and focusing on whether there was an attempt to avoid EIA, but then saying, but the grid connection would be subject to separate consenting anyway. So there wasn't an avoidance, as it were. But that's where the court was saying, well, that's not the right question. The right question is, are they one project? Not if there was a degree of avoidance, or not if the grid was going to go through separate consenting, so its effects would be taken into account and assessed anyway. And again, on this theme of not reading too much into the court decision, what I've picked out on this slide is what the court didn't decide. And they didn't examine what is the next step if indeed the wind farm and grid are one project. How, in assessing environmental impact and bringing forward environmental information, how do you deal with the practical difficulties? And that's really, as I was mentioning, the fact that information on the grid, detailed information, almost certainly will not be available. And that's where there's a lot of head scratching at the moment. And it'll be very interesting. I was talking about, the next few months, possibly the next year or two, seeing how solutions emerge as people grapple with that part of it. So at the moment, what existing applications for renewable energy generating assets, so wind farms, solar, etc., etc., what they're all having to do is to address this question of, are they one project? And if you look at the National Planning Hub website, the information on this EIA training project, there's a series of articles, and there is an article looking at, it's a basic explainer article about how you define the project and setting out the cases. It does mention salami slicing, which in retrospect is perhaps a little unfortunate, and I feel I've fallen into the same trap the reporter fell into. But it sets out the cases, including the famous bridge to nowhere. So it gives you a background about the legal principles that you apply in deciding whether or not they are one project. And you will not be surprised when I now say that's not necessarily a straightforward question. It's obviously going to be very circumstance specific, but as ever, applying general principles to individual circumstances isn't necessarily straightforward. So that's, again, causing us a lot of head scratching. So that is my just very quick run through the Rochdale Farms, the Woolmuir court decision.